Then I'll also take us through some risks and case scenarios in the creative sector. And then I'll conclude by guiding us on how to go about such risks and also sharing some practical strategies on how to navigate the delicate balance between compliance and creativity. Well, these now are the key compliance obligations under the Data Protection and Privacy Act, which is Chapter 97 of the laws of Uganda. Over and over again, I'm going to keep referring to it as the DPPA. Please don't get lost. It's the Data Protection and Privacy Act. Well, first of those obligations is renewal and registration with the Personal Data Protection Office. And these are provided for under Section 29 and Regulation 15. I want to believe most of us on this call know what we mean by renewal and registration, which is only the first step in your compliance journey as a data collector, processor, or controller. The law requires that if you fall anywhere under those categories I've mentioned, data controller, collector, or processor, you ought to register with PDPO. And failure to do so is actually an offense. And we shall look into this as we go along. But that's just the first obligation you should take note of. Then the second is to adhere with the data protection principles. These basically are provided for under Section 3 of the DPPA. Just going quickly through them, there are accountability, processing data fairly and lawfully. Then there is the principle about retention. It basically speaks about how long you're supposed to hold on to the personal data you collect. Then there is quality, which is basically about the accuracy of the records you hold as a data collector, processor, or controller. But then there is transparency, which is basically you being transparent to your data subjects, keeping them in the know, in the loop or on how you process their personal data, how long you keep it, where it is kept, and all such things. Then important too is the principle on security. It's basically how secure you keep the records you have about people. And their principle I didn't mention is on adequacy. And basically the import of this principle is that you only must collect what you need to fulfill the purpose of the collection you're undertaking. Say, for instance, you're a developer, or maybe you're doing a gaming app and you want people to register, maybe to be able to access it. I don't think for anyone to be able to use your gaming app as a creative developer, you need to know what their blood group is, or even political affiliation, or maybe such things. So the idea is that you only collect as much as you need to fulfill the purpose for collection. Then the other compliance obligation under the DPP as we proceed is the security measures for protecting personal data. These are provided for under Section 20. And I realize this actually is in tandem with the principle of security I just talked about. The law requires that for as long as you collect anyone's information, you must keep it secure. You must have measures in place to keep that data of anyone secure. Then the other compliance obligation is to do with the rights of the data subjects whose data you hold. Just to take us quickly through these rights, they're provided for in sections 24, 25, 26, 27, and 28 of the DPPA. First of those rights is accessing the information you hold of data subjects. I, as a data subject, have the right to access all the information you hold about me. And the other right is for me to prevent you from processing my personal data. Say maybe I was onboarded onto your software, or maybe just think about it, anything in the creative sector. It could be an event where you collected our information, a ticketing app, but maybe after the event, I wouldn't want you to hold on to my data any longer. Or maybe even during that process itself, I might opt out. So as a data subject, I enjoy the right to prevent you from processing of my personal data. Further to that is the right for me to prevent processing of my personal data for direct marketing. So for instance, you collected my personal data as a developer, maybe as an event organizer or something like that, And you would maybe like to use the same information to market your other products to me, or maybe to share it with anyone else to market their products to me. As a data subject, I have a right to prevent you from doing that. Then the other right is about rectification, erasure, and destruction of personal data. As a data subject, I enjoy the right to ask you as a data controller or processor to have my data rectified or erased. Realize at the point of onboarding data subjects, at times mistakes are made, and even maybe over time, a lot of things change. By the time someone maybe joined your, was onboarded onto your software or anything like that, they could have been of a different age, or maybe they could have been not married. That would mean they have only two names at that point in time, but maybe over time they got married and they would want to update all that information. It's well within their right for them to ask you to have that updated. So as data controllers, processors, and collectors, we must be keen on this. Then finally, the other compliance obligation that might apply to us in the creative sector is the bit on cross-border data transfers. You realize most of the creative sector is so intertwined so much so that you realize most of the companies that are into this sector operate across borders. It could be a media house or maybe a production house with presence all over Africa. So what happens? These people are going to keep on sharing data among themselves. It could be within the same company, but it's going to flow across borders. Take the example of MultiChoice and Netflix, all such companies. They are present in multiple jurisdictions, which would actually mean that there is information they share among themselves, still within their company, but it's across borders. So what the law requires is that before any such transfers happen, as a data processor or controller, you must be sure that the jurisdiction or country to which you're sharing information has adequate measures in place to have that information protected. Well, and just to go a little further on that, some of you might be wondering how such adequacy is assessed, or maybe how you should find out whether, say, for instance, DRC has adequate measures in place. What happens? You're supposed to look at their legal framework and compare it to ours. And what we want you to show us is that, say, for instance, Switzerland has the necessary legal frameworks as regards data protection, and they are adequate enough to protect the data you're going to transfer there. It could be for hosting purposes, name it. It could even be under just within your organization or company. But we want you to show us that that country to which you're sharing personal information has laws or a legal framework comparable to ours, maybe equal to ours or better. Anything out of that would be in breach of the law. If we ever found out that you're going ahead with such processing, having not assessed the adequacy of the laws to the place where you're transferring personal information. So basically, that's it with the compliance obligations. And in my next slide, we'll just look at an overview of the creative ecosystem as regards data protection. This is just for us to sit back and think. Out there, I know the sentiment is that in the creative sector, the way of operation or how people go about things is mainly laissez-faire. So one might wonder, do players in this sector actually rely on personal data at all? And if they do, how does it happen? Just think about it before we get the answers in the next slide. Well, our answer is right here. In the creative economy, personal data is actually the new oil in quotes. Look at the economy as any machine that will need to be lubricated for it to function properly. So what personal data does is that it's going to keep this machine running by lubricating it, which would mean that without it, the machine is going to, if it's an engine, it will experience a knock. So it basically can't function without personal information. First of the examples I got is in I would call them apps for now, but they're the most time softwares that provide this creative content. It could be TikTok, the social media apps, TikTok, Instagram, and all the like. What happens is that as you scroll through, you're going to realize that there is a particular kind of videos they're going to keep bringing for you. Even in as much as they didn't even come to you to ask what kind of content you like. You might have given them your preferences, but even without that, somehow they're able to find out. Those are the guys behind those apps. And guess what? How are they able to find out that you're interested in such content? So, for instance, you're onboarded onto, I'll use the example of Instagram, and your profile picture is, say, you have dreadlocks in your profile picture, and then as you go through their app, they are able also to find out that the kind of music you listen to is most times reggae. So what this app is doing in the background is they are profiling you. And by profiling you, at least having connected the dot of you having dreadlocks and listening to reggae music all the time, they're able to know that this kind of person might be interested in the Rastafarian culture or such things. So you're going to realize that they're going to bring you such content over and over again. As a user, it might just turn out as interesting because that's what the app is all about, is to have you relaxed and enjoy your free time or whatever. But then you forget that maybe they're using your personal information to make you enjoy the app better. Now, this begs the question of what else can they use that personal information for? Remember, they didn't, say, for instance, sync your consent getting that kind of information from you. All you did is onboard on the app, use your picture, and start searching your things. But then these people are profiling you and starting to create content specifically made for you. How is this made possible? Your personal information. That is your picture and your preferences as regards your searches, your usual searches. Then number two is creating interactive content. Still in the creative sector, there are people that do gaming apps. It could be FIFA and all those. What happens is that at times they want people to experience live interfaces while using these apps or softwares. So what happens? They're going to first of all find the time zone you're in, and they're also going to connect you to someone or maybe all the other people within your time zone or even people within your vicinity. That is the location. In the background, what these guys are doing, they are seeing that maybe this is Gilbert accessing our software from Mengo, but then there's also someone else around Rubaga using the same software. So they're going to give you suggestions on who to play with live. You realize that for them to be able to do this, they're first of all accessing your location, but then there's also other kinds of personal data of yours they're accessing in order to connect you to these people. As a user, it is going to be interesting, but what we should always have in mind, first of all, as users, but again, as developers or stakeholders in this creative economy, is that how are we handling this personal data we are collecting from people? Are we using it for good purposes, or is it necessary for us to serve these people that we have onboarded on our softwares? Then the third is to develop products and services tailored to consumers' preferences. This is pretty much straightforward. And I'll actually use the example of still in the creative sector. I know there are fashion designers and artists, so to speak. You know that even for them to get you that nice dress, that nice jacket, suit, or whatever, they need to have your sizes taken. If you're purchasing from a website like Say Next Tailoring or such websites, they're going to get your sizes and they'll have them there. I don't know for how long, but they're going to have them there and they'll keep suggesting for you their products based on your preference, but also on your size, which is all your personal information. The number four is leveraging algorithms to analyze consumer viewing habits. I explained earlier on that about these social media apps. I used Instagram as an example. If they find out that you're interested in say, content to do with artificial intelligence, many a time they're going to suggest such videos to you. But how did they find this out? Algorithms might themselves not be personal information, but let's see them as the recipe and personal information as an ingredient. Saying algorithms might themselves not be personal information, but they have elements of personal information in them, which is the ingredients used to build those algorithms. Now, how algorithms work is that they're going to, I would say, study you, so to speak, and they're going to keep suggesting to you such kind of content tailored to your preference. And how is this possible? Remember, in the background, there is your personal information used to build these algorithms. So this is basically how personal data keeps on oiling the creative economy. The number 5, that is targeted advertising. You might keep wondering, say you went on Google and did a random search, events in Kampala this weekend. You selected one. It could have been, I don't know, a rock night. But then weeks later or maybe months later, you keep seeing such adverts keep coming to you. How is this made possible? Your personal information was collected at the first just by you accessing these people's websites and kind of letting them know what your preferences are and location. Then number 6, content creation and monetization. I believe there are people on this attending that are into content creation. And if they will bear me witness, how are they able to monetize their content? Before they do that, they're going to need your financial information, your location, because some of the softwares that pay out for this content creation don't operate in some locations. So they'll need your location details in order to make this possible. But then you realize still in the background, all they need to make these payments possible is your personal information. And even for the creation of self of the content, you're going to use people's personal information to have it done. Personal information or personal data goes to things as negligible as your personal picture, your videos, your name, all such things. So imagine content being created without people's pictures, names, their videos, and such things. So this is basically to show us how personal data oils the creative economy. And moving forward to the next slide are just examples on the kind of data collected by processors in the creative industry. Names, like I mentioned, email addresses. Many of us buy those tickets from those online selling apps for events. You know how much information they ask for. It isn't just your email address, but they'll need, it could be your Visa information, MasterCard, whatever you're using to pay. Telephone contacts, of course, payment details, which is also still your financial information, personal photographs, and then analytics and personalization surveys. Well, that's just some of the examples. There are many, many more I could give, but in the interest of time, I'll move to the next slide, which basically is to show us examples of the risks in the creative sector as regards personal data, but also to give case scenarios. These are not hypothetical, they're actually cases or maybe scenarios that have happened in real life and their effects have been so far-reaching. Well, number 1 is forgetting third-party data security. As players in the creative economy, realize it's I would say it's so intertwined. I mentioned earlier. So, for instance, you're organizing an event, you need someone to do the production for you. You need someone to do the ticketing. You need someone on hospitality and many other service providers. So in order to put your product out there, you're going to need at least 5 people on board, which would mean you're sharing your attendees' personal information with these people. I'll still use the example of event organizers. You're organizing an event, but say for instance, FlexiPay is doing the ticketing. It could be MOOC, Tag Ticketing, Quicket, and all such companies. In this, you're going to find that Quicket is going to collect all your attendees' personal information, but then this is you organizing an event, and the people know it's at least an example of say Talent Africa. They're the ones that do Nyege Nyege. The people that went for Nyege Nyege don't know who did that ticketing. Only what they got to see is a ticketing site that was shared to them. They went bought the tickets, but they know it's Talent Africa that organized the event. Now, say for instance, the ticketing for Nyege Nyege was handled by FlexiPay or Quicket. Quicket is a different company from Talent Africa. The people going for the event have in mind it's Talent Africa organizing. But then Quicket is collecting their personal information. If it so happens that a breach happens that say Quicket faces a breach and these people's information is disclosed to the general public, who are they going to go for? They're going to go for the organizer that was Talent Africa. So the risk in this is because I mentioned the breach happened at Quicket. Quicket was a third party. So the risk, like I was saying, is between you, the data collector, processor, and the third party you're dealing with. If you don't do your due diligence to ascertain that their security measures are up to scratch, and maybe that they are, I would say, certified or they qualify as data collectors and processors, and you risk having your attendees' personal data misused. What I'll just give us the practical strategies as we go along, but that is just to point out this kind of risk. The other example I have is with Spotify. Spotify, as big as they are, have faced these things. This is from about a month ago, where their payment information got, their users' payment information and emails got exposed to one of their third parties. The breach was at a third party, the one handling their payment. I think if you can read from the screen, I hope this is clear enough. They're saying that Spotify users should check their registered emails if they have been notified about the recent data breach. And that's what actually happened. And the reminders down, which are like tips for the users of Spotify during the time of the breach, were that you shouldn't use your email that you use for Spotify with your online banking. Because remember, a breach had happened at the other third party's site, and people's information was out there. So, as you might know, fraudsters also work day and night, same as hackers. So they might take advantage of all this information and like I was saying, the take home from this is just to make sure that whoever you deal with in this ecosystem at least is compliant. I mentioned that one of the functions of PDPO, or maybe one of the obligations of data collectors and processors, is to register with PDPO. The Personal Data Protection Office has a register of all registered data collectors, processors, and controllers, and this is publicly facing. So just as part of your due diligence, before you deal with anyone, it doesn't hurt checking that register just to confirm that these people are at least registered, which is only a first step in their compliance journey. Then in the next slide, we are now back home. This is into the real event world. What we have on the screen is a case that happened about 3 or 4 years ago, and it was against Swangs Avenue with someone called Seru Jude suing them. I'll tell you what the story was. This person attended one of their events, one event organized by Swangs, and they had their pictures taken at this event. And their pictures were not only taken without their consent, but they were published somewhere. So what happens? This person sues the company, first of all, for using his picture without his consent to market their event, but again, for collecting his personal information that is his picture without his consent still. So at the time, I know there is there are people from Swangs Avenue, and they call, no offense to you at all, but I wouldn't blame them as much as I would today, because this is 4 years ago and awareness wasn't as much as regards data protection. The event was organized without a privacy notice. What a privacy notice is what we are going to see in the next slide. But even then, the argument they gave, I don't know if any of us have interfaced those ticketing apps whereby, say, by buying this ticket, you consent to having your photos taken and whatever. We're going to look at that in the next slide. how the Data Protection and Privacy Act defines consent wasn't reflecting in these people's privacy notice. Not even a notice, they called it a disclaimer, and it was in the ticketing site, not even at the event premises. So what happens, how the case ended, just fast forward, is that these people had to concede and settle out of court. That is the company that was sued. But now one would easily ask that, does merely purchasing a ticket to an event imply consent to one's photo being taken at the event? Just think about it. I was mentioning, as trying to take us through the definition of consent as it is in the Data Protection and Privacy Act. Just before we look at what this people's notice was. Consent, as we all might know now, must be unambiguous. It must be by affirmative action. And it must be, okay, the best practice is that it must be in writing. But at least, even if you can't achieve that, there must be some proof of you having obtained that consent. And consent must be direct. You can't just imply it from something. So as players in the creative sector, we must have that at the back of our minds. Someone is at your event, you take their photos, and your defense is that, okay, by accessing these premises, they consented. By me walking into a building doesn't necessarily mean that I'm consenting to having my pictures taken, unless I'm told before I access the building that by you doing this, you actually are consenting, and I must be given the option to say yes or no. That is what consent basically was envisaged to be by the framers of the Data Protection and Privacy Act. So in this slide, I would request that we just have a look at, they call it a disclaimer, but the essence of it was for it to be a privacy notice. If you can look at the second paragraph, they said purchasing Ghost and Rhyme tickets shall be taken to grant consent to the organizer, capturing photos or videos of the attendee, which may be used by Swangs Avenue or its licenses for purposes permitted under the DPPA, including but not limited to advertising future editions of the event. Now, in this is about three things. One, they are saying that by purchasing this ticket, you're waiving your image rights. That is your copyright, so to speak, because they're saying we can use your picture for commercial purposes. That is marketing our future events. And they did not mention anywhere that you're going to be compensated for this. Above all, they say you're waiving or maybe you're giving us consent outrightly just by purchasing this ticket. Remember what the definition of consent is. It must be direct, it must be by affirmative action or statement, and it must be unambiguous. So I think we all can see that this is a bit problematic. I thank God I'd actually have to mention it here. Swangs Avenue are a compliant company now because we've supported them in many ways. And at least I know for all the events they've hosted after this has changed, and we've taken them through best practices on how to go about this. For instance, in the event world, at least now they know that for people purchasing these tickets, if I don't want my pictures taken, it isn't right for me to say, don't come to our event. What happens is that tell someone to come, but give them, say, a different wristband. If everyone else has a white wristband, give this person that doesn't want their images taken a red one, so that your photographers know before they take their photos, they take their images at the event. Well, I think that kind of drives the point home in the physical world, that is events. Now, in the next slide, the other scenario, still back to the virtual world now. This was a complaint against Google recently handled by the Personal Data Protection Office. I know some of us could have had the benefit of reading that decision, and the take home from this, one might be wondering, Google is mostly known for their emails and all the other systems, and we might not think about the creative bit in all this. Google, as a company, has other subsidiaries, one of which is Google Arts and Culture, but then they also have those generative AI models. And all these are enablers of the creative sector, just like you had arts and culture. So Google, by not complying with the Data Protection and Privacy Act of Uganda, was complained against, and okay, the story is on the screen, but I'll just tell you. These people lodged a complaint challenging the processing activities of Google, that is the respondent. And they were saying that Google transfers people's information to wherever they do. First of all, not having registered with PDPO, but also not doing the adequacy assessments like I discussed earlier on to ascertain that the countries to which this personal data is transferred have proper legal frameworks in place. The decision was that Google was in breach of the Data Protection and Privacy Act. So as developers, or maybe as players in the creative economy, if you're running, say, a gaming app, it's not limited to just Uganda. People in New York, Canada, wherever, they can access this app and they're able to be onboarded as data subjects. But just think about it this way. Are you compliant to the laws in all the countries where your app is being used? Just like I mentioned here, non-compliance with legal obligations under domestic law is the risk. If you don't comply with what the law says in all these countries, you risk being sued, and at times the penalties are quite hefty. And let alone the penalties, but your reputation too as a developer or as a content creator, or just imagine anything in the creative sector, your reputation is going to tank overnight if it's out there in the news that this person is not compliant with the data protection laws that are in place. Well, moving on, we'll now look at the practical strategies to navigate the delicate balance between compliance and creativity. It's said many a time that complying with the laws, or rather that the laws kind of stifle creativity and innovation, which actually is not true. And I'm going to just take us through a practical look at it. Number one, if you have a ticket selling website, an event ticket selling website, does it have a privacy notice? Are people accessing this website made known to what their rights are? Do they know who to complain to in case their information is misused? All that should be on your website, your selling website. Or maybe say you run an app or maybe a website where people go and interact, share pictures, the likes of Facebook, Instagram, and all such things. Like I mentioned, these people use algorithms that are supported by our personal information. What collects this personal information? That is what we call cookies. I know most of us have interacted with this. Accept cookies, reject, accept all, accept only necessary, such things. Do you have a cookie management policy in place as a developer? Because that should inform your practices as regards collecting people's personal information on your website. Well, the take home here, the strategy is to have cookie management policies and as well be transparent to your data subjects. So are you transparent to them? Have a privacy notice in place. Not just terms and conditions as many people have on their websites, a privacy notice. Then moving on, we should always see to it that we obtain data subjects informed, unambiguous consent before onboarding them for any product. Realize that every other time your defense will be that, you know what, yes, I used this person's personal information or personal data, I collected it, processed it, but then I had their consent. Even if they came and complained and your phone may be in breach, it wouldn't be the same as where you just grabbed the personal data from them, you stole it, so to speak. So let's just see to it that we always get people's consent before collecting their personal information. It could be pictures, videos for content, name it. Always see to it that you get people's consent. And then number 3 is assessing third-party data protection policies and practices before partnering with any external vendors. Don't forget to ask the tough questions, because remember, you're trusting them with your users' personal data, and these users know you, not that third party. So you're basically the link between the third party and your user. So before you trust them with any personal information, at least be sure that they are compliant and that they have policies in place to have that personal information protected. I gave the example of Nyege Nyege, the event organized by someone else, but then the ticketing done also by someone else. It's very okay, it's normal, but at least be sure that whoever you're dealing with has proper measures in place. Then the other one is establishing contractual agreements that hold third parties accountable for any breaches or misuse of personal data. Well, the brief term for this is data sharing agreements. You're an event organizer, someone is doing your ticketing, which means they're going to access your attendees' personal information. In case a breach happened on their side, who is held accountable for this breach? And if there is any compensations to be made, who is supposed to do this? This must be in your data sharing agreements. There must be such clauses as to do with liability when it comes to breaches and all such things. The other is to choose to have a centralized data management system that integrates several functions in one platform. So for instance, you run a website that I would say sells your products, but also gives people room to interact and maybe recommend other products to other people. What we basically are saying is that you must have a centralized data management system. Make sure that all the personal data you collect is in one central system whereby you can first of all control it, and it actually makes it easier to have it safeguarded. It would be different if you have these several platforms. You could be running a conglomerate of companies. Say, for instance, Meta, they have WhatsApp, Instagram, and all those. It's different. I think it's much easier having a central log for all these processing activities and the personal information you collect, as opposed to having it scattered everywhere. This can be like how I'm going to talk about this as we conclude on how the office is willing to support in such things. And then we should as well have contingency plans in place. Well, as you might know, you might have taken all precaution, done everything like I've discussed, but breaches happen and it's normal. You saw it happen to Spotify and many other big tech companies. How about your startup down there? It can happen even in as much as you take all the precautionary measures I've guided you on. So what a contingency plan does is that it can be the difference between a manageable hiccup and a full-blown crisis. If a breach happened to you and you have a plan in place on how to go about it, at least you won't panic. You won't be all over the place trying and testing out all sorts of solutions. If you have a plan in place, a good one, at least you'll be guided on how to go about everything and how to handle best such breaches. Then finally, training. Training. This is for your users, say for your employees in the company, and for everyone you deal with. I would say that learning in such fields of life never ends because they're always evolving. If you're trained today on how best to go about breaches, you don't know what the hackers are cooking maybe next week. So you might have to be trained on that too. So just keep on training and making yourself available to learn. And then, I mentioned PDP, or the Personal Data Protection Office, is always there to guide you on how to go about all these. Feel free to reach out because it's part of our mandate as PDPO to guide you on, say, for instance, how to come up with those central logs, how to do data mapping exercises, how to go about adequacy assessments if you're into cross-border data transfers and all such things. Feel free to reach out. I'll display our contacts as I conclude the presentation. Then the consequences for non-compliance. The first of them, say that is to your company or institution, you can be fined up to 2% of your annual gross turnover, which actually would be a blow to your company's finances. Then for the individual that occasioned this breach of the law, you can be imprisoned for anywhere between 3 months to 10 years. Well, This slide now shows us what our contact points are as PDPO. We are located on Padre Pio House, that is Lumumba Avenue on the 7th floor. That is our email. Feel free to reach out in case you have any inquiries or you need to seek guidance. Our website is there and the telephone contacts. Well, I think I'll hand over to Anita to take us through the Q&A session. She'll just help me read out as I respond. Yeah.
Okay, thank you so much, Gilbert, for that very insightful presentation. You did shed light on the common data risks in the creative sector, and most importantly, thank you for sharing the tips on how we can navigate the delicate balance between compliance and creativity. For the participants, I really hope and believe that we have taken note, especially of the strategies, and will be able to put these in place. Now, allow me go to the Q&A session. I'll start with the questions in the Q&A section. Members, please, if you have any questions, kindly type them in the Q&A section. Normally, when you put them in the chat, sometimes we miss them out because there is a lot going on in the chat. So if you have any questions, please type them in the Q&A panel. Gilbert, I'll be taking 2 questions and you respond, then I take 2 more. Just we'll be moving like that. So the first question from Serena. Serena says, does that apply to offices, places with CCTV? What she means is that, do you have to notify the people coming to visit the organization that there are cameras in offices? And then the second question I would like you to take as well. Someone says, take an example. Wilbur says, take an example of a conference. Do I really have to get everyone's consent and how? Over to you.
Thank you for the questions. I see, Serena. I think the question was about accessing premises with CCTV surveillance. What I see most of the time is that there is notices before you access those premises that, okay, maybe you're accessing this place, but it's under 24 hours surveillance. That is CCTV surveillance. So Serena asked whether
Gilbert, are you there?
I'm just trying to find that question. I just
So
want to
her
be sure that I'm
question
responding
was,
it.
do you have to notify the people coming to visit the organization that there are cameras in offices?
Yes, you do have to notify us. Because number one, by you manning those cameras, you're collecting our personal information, you're collecting our photographs and video footage. But how we go about this is you having a privacy notice at your premises. Because at least I'll know that my information is being collected, that is, my photographs are being taken, but it's for purposes of security. And maybe we only keep this footage for 3 months and all such things. If you're offended by this, reach out to this person. Like I said, reach out to PDPO to guide you on how to go about drafting your privacy notice. But yes, you must notify the people accessing your premises. That can be done through a privacy notice. Then someone else asked whether the same is required for conferences and how to go about it. At least I know that for conferences, before people access premises, they have to register somewhere. On your registration form, it doesn't hurt adding a column, maybe asking for people's consent for their photographs to be taken, and also letting them know on the same form maybe why you're collecting their information. It could be for your records as an organization. Maybe if you want to reach out to them for future events, they must consent to that. But yes, the bottom line is you must let them know that you're collecting their personal information. And not only that, but you must get their consent for that information to be collected. Thank you.
Okay, thank you so much, Gilbert. There is a very interesting question from Doreen. She shared a sort of a short privacy notice. You're going to allow me read it. So she says, thank you, Gilbert, for the very insightful session. Kindly advise if we have the below photography privacy notice at the entrance to our event. Does it suffice? The the privacy notices as follows. By participating in the event, you are giving consent for us to take photographs for promotional use, printed publications, online marketing, social media platforms. However, be assured that we will always adhere to the Data Protection and Privacy Act 2019 in regards to your personal data. If you'd like to opt out of this, please let us know. Join us and let's ensure every aspect of the workshop is captured in the best possible way. I hope you have been able to capture that, Gilbert.
Yes, I have. Thank you. Well, there is about 3 parts in this notice. One, they say that by participating in the event, you are giving consent. Let's not forget the definition of what consent is. It must be direct, unambiguous, outright by an affirmative action or clear statement. Just think about it along those lines. By me participating in an event, what would you have to show as evidence for me having given you my consent? Think about it as the organizer. Number 2, please be assured the other aspect of this privacy notice, Anita read out, that you're giving consent for us to take your photographs for promotional use, publication, online marketing, and etc. Now, what happens is another twist to this, which is in the realm of intellectual property, that is someone's image rights. Because now you're using someone's likeness or their photos to market your event. Remember, you're earning from this event using their photographs, but you're not compensating them. Under copyright, this in itself is not right. In as much as you have someone's consent, they must be compensated, or maybe they must have waived their entitlement to such compensation. What I like about it though is you give someone the option to opt out if they're not okay with this. But opting out shouldn't mean I don't access the event. You must at least provide me with the special measures for me to still access your event, but not have my photographs taken. So on a scale of 1 to 10, I would say, I think a 6 is enough. But reach out, you can always get on how to phrase this notice best. Yeah. The other
Okay,
question,
thank you
Anita.
so much. Thank you very much, Gilbert. Doreen, I hope that answers you. We have another question from Sadiq. Sadiq says, during data collection, video, photography in schools, who can consent for the children? And then I'll read another question so that you take 2 at once, because I see we have quite a number of questions. Simon says, is it allowed to share employee data outside Uganda for money laundering screening? Over to you, Gilbert.
Well, what the law says about children's data is that you must not collect children's personal data. However, there are exceptions to that particular section of the law. Number 1 is that if you have their parents or guardians' consent. Number 2 is that if it's for research and statistical purposes. And number 3, if it's to perform a legal obligation. So, for instance, it's the Statistics Authority coming to do a census. They won't need anyone's consent. They're going to come and collect the children's information. If you have their parents' consent, yes, you can go ahead and do that. But now in the context of schools, I know some schools do. As you take your child there, they're going to have you sign some forms whereby say that they're basically saying that for the time that the child is at school, you're giving us the authority to one extent to be their guardian or maybe to consent for them as regards certain things. So if this child's parents sign such forms, at least the management of the school can consent for the children. But if they didn't, you would have to look for their parents to consent for them. And best practice, at least be sure that there is evidence of maybe the school having those forms signed by the parents. But in no instance will you find that a child is consenting. Remember, they are underage and they, I would say they can't appreciate what consent is and what it isn't. They're always going to say yes. So children can't consent, but their parents can do it for them or their guardians. Then the other question was, can you share employees' personal data? Was it for money laundering screening?
Yes.
Well, I hope I understood it the proper way, because I know the Anti-Money Laundering Act provides for certain things. Among them is doing those background checks on people. If it's anywhere provided for in the law that you can share people's information to maybe, I would call it an investigation of sorts to find out whether they're into money laundering or such things. If there is a legal obligation for you to do it, yes, you can go ahead. But even then, this law has no exception for anyone, be it a government entity, a private company, or whoever. As long as you're transferring personal data outside Uganda, yes, you must be sure that wherever you're transferring that personal data, there is a proper legal framework to have it protected. So yes, number one, you can go ahead and do it if the law allows you to. But in as much as you're doing it, be sure that you're complying with the same law again. That wherever you're sharing that personal information, there's adequate measures for you to be protected.
Thank you, Gilbert. Now, Juan Emanuela says, does this also apply to religious institutions where people gather to pray? If yes, how can compliance be ensured? I'm going to combine this with Lillian's question. Lillian also says, how do churches go about getting consent from the congregants? That basically would be question one. And then Majid says, how do entities qualify to be data collectors or processors? Are there formal requirements? Over to you.
Well, the Data Protection and Privacy Act is not segregative at all. It applies to every data collector, processor, and controller. They could be in Uganda or they could be outside Uganda, but collecting Ugandans' personal information. So churches, in the circumstances, are not excluded. They must comply. And how do they go about maybe getting consent from the congregants that they show in their TVs, live streams, or such things? Well, I would just like to say it as it is. If they don't maybe have you sign somewhere before you enter the church or such things, maybe consent can be obtained in a lot of ways. It could be a click-through agreement, but as long as there is evidence for them to show that you consented, they are in breach of the law then, but your consent must be sought before they process any of your personal data. Then the other question was how
The
does
other
one
question,
qualify to be a data collector or processor? You don't qualify to be one. As long as you collect any personal information from any Ugandan or anyone resident in Uganda, you're already a data collector or processor and controller. What the distinction is that who is a data collector, who is a controller, who is a processor. Number one, there is no qualifications that maybe you must do this to qualify. As long as you collect that information, you're already doing it. Then processing is basically, I'll just use examples. Still back to our example of Nyege Nyege. The event organizer got these people's information. Like they organize the event, but then someone is doing the ticketing. So they are having gotten their revelers' information. For them to get tickets, someone is processing that. So the third-party ticketing site is a data processor on behalf of the data collector and controller that was Nyege Nyege. Controller is that person who determines the purpose for each personal data is collected. Then processor is that one who just think about any sort of processing. In the context of employment, it comes out clearly. HR at your workplace collected your records, but then they provide for you insurance covers. Your company isn't an insurance service provider, so they're going to get a third-party company. It could be UAP, Jubilee, or any other. So these people are being given your records by HR at your company to process for you insurance, health insurance. So in that context, the data collector is HR at your company. They are still the controller because they are determining the purpose for which they collected your personal data. By then, the insurance company is processing this data they got from you on their behalf. So that's basically the distinction. But qualifying, as long as you do any of what I've said, you already won. Yes.
Okay, thank you. Thank you, Gilbert. I can see it's already midday. I'm going to take only about 4 questions and then we will unfortunately have to close the session. Ivan was asking about a data sharing agreement. He says, should a data sharing agreement be a separate standalone agreement, or it can be a clause in a master agreement? And then the second question you could maybe take with this, Majid says, when you're in a public setting, like an LC meeting, I assume that's a local council meeting, how does one seek consent or record footage, video or audio, if this information is for personal records or creative work?
Okay, I'll start with Ivan's question. Should a data sharing agreement be a separate standalone agreement, or can it be a clause in a master agreement? Well, it could work both ways, but best practice is that it's a standalone agreement. Simply because a typical data sharing agreement is going to have a lot in it that might not fit in one clause, in just one clause in an agreement. Because there must be issues with liability, retention, and all such things. So it can work both ways, but best practice is it being a standalone. Then public setting, LC meeting, clan meeting, name it. Well, I must admit, we all know this. The African society is like data protection isn't our thing. Privacy, okay. At large isn't our thing. Just like you might know you're out there in a client meeting, they're going to, even before you ask anyone what what their information is, someone is going to say, in Luganda, I call it kutambula ng'Omuganda. Even before you seek this information, someone is going to tell you where they are buried, who their great grandfather is, who their parents are. Even that is even before you ask, and that is just part of an introduction in these meetings. So, number one, I appreciate data protection and privacy aren't inherently our thing, but it's a work in progress. We shall get there at a point in time. But just to answer your question, how does one seek consent to record this footage? Best practice still, have them sign somewhere before the meeting starts. Same way you registered for this meeting and you are told that it's being recorded and all that, you must let people know. And at least, just like they say that if it's not documented, it didn't happen, you'll have a defense against them if they ever come back in future and say that, you know what, you collected my information without my consent. If you have something to show for it, you're protected. But if you don't, it will just be your word against theirs. So still, best practice, obtain their consent. They could register before the meeting starts and sign somewhere, just as proof to show for them having consented. Yeah.
Okay, thank you, Gilbert. Now, another related question. I think consent has really been interesting. Someone says, Martha says, is consent from LC leaders or community leaders enough to get data from an entire village, like photos or videos? And maybe the last question you will also take on from Peter. He says, should the consent be written on in some form of record? I would ask that you take those two and then we'll end the Q&A session here.
Well, like I mentioned in the definition of consent, it must be obtained from the data subject themselves. I can't consent for anyone else except my own children, since they're under my guardianship and they are underage. But anyone beyond that, I can't consent for them. So an LC chairman consenting for an entire village is actually invalid consent. I'll just use an example quickly. There's someone in the creative sector I once worked with. They are trying to do a documentary of the street kids on the streets in Kampala, and they were wondering how they're supposed to get these children's consent. Because just like you might know, these kids they're on the streets for many reasons. They could have escaped from their homes. Their parents could have, I don't know, they could have died or something. So one wonders, how do you obtain such consent? See, there is always ways you're going to be protected in the law. And for this particular scenario, at first thought, it might be a bit challenging, but if you think deep about it, you realize that KCCA is in charge of this city. And these kids, I would say, are children of this city. So the best person or the closest they could get to having consent to have his kids recorded was KCCA. So at least this person got those permissions, and if these kids ever came back in future to complain, or maybe anyone, there will be something to show for at least these people trying to comply with the Data Protection and Privacy Act. Then there was some other question. Anita, I beg your pardon.
Someone was asking if consent must be written or in some form of record.
Well, back to our definition of consent. Clear affirmative action or statement. Best practice, have it written. Because I mentioned if it's not documented, it didn't happen. Just envisage a scenario where you got a yes from someone, a verbal one, but 10 years later they come back and say that no, they deny having given you that yes. If you got them to write somewhere, you'll have a defense. But if you didn't, in as much as you might have gotten their consent, it would be so hard to prove it to court or whoever you're appearing before. Yes. So best practice, have it written.
Hey, thank you so much, Gilbert, for being able to respond to the questions. Members, you will pardon us. We are not able to take all the questions. However, you can keep the conversation flowing on our social media pages. I have shared a link in the chat. Kindly click on that link and give us feedback on today's presentation. The feedback you give us helps us to make any future webinars better for you. And for those that have been asking for the presentation, kindly note that this is going to be shared on the emails that you used to register for today's webinar. I am going to give it about 5 minutes for us to be able to click on that link and provide feedback. But in the meantime, Gilbert, I am going to come back to you for parting shots. And once that is done, we'll be able to close this session. Gilbert, for now, over to you for parting shots. So anything you feel you needed to talk about that we may not have addressed. And as that happens, participants, kindly click on the link and give us feedback as well. Over to you, Gilbert.
Okay, thank you, Anita. Mine, first of all, is to thank you that have taken your time to attend this webinar. I believe it wasn't a waste of your time. And I'll request that we keep the conversation going. Go and feel free to reach out anytime for guidance, for any inquiries, or maybe for anything that you feel I haven't tackled properly in this particular discussion. Well, in the creative sector, like I mentioned, it's still a work in progress. And yeah, I hope at a point in time we'll get there. But at least as individuals or players in this sector, let's do our best to have it, to see to it that we observe data protection. Yeah.
Okay,
And
thank you so much,
above all,
Gilbert.
thank you again for attending.
Okay, thank you, Gilbert. Maybe in the meantime, you could put your slide that had contacts.
Okay.
Okay. For those that would like to reach out on different areas, those are our contacts on the screen. Please feel free to reach out to us whenever you would like to. Thank you so much, everyone, for your active participation and the thoughtful questions. And a special thank you, of course, to our speaker for today, Mr. Gilbert Setuma, for breaking down today's topic and, of course, giving us the insights and strategies on how the creative sector can really balance innovation and compliance. We appreciate your time and engagement this morning. A recording of this session, along with a presentation, will be shared with you after this webinar. We look forward to having you join us for the next month's session. Have a great day and thank you once again for being part of this discussion. Bye.